Okay, abusuan ba makwa abashonko so ereba POG Media so abusuan yembonra yensemu 5-member committee a yete amote Chief Justice Torkonoo ne remover ane so no abusuan CCA no sa 5-member committee no omo arefe Chief Justice Torkonoo suspended Chief Justice Torkonoo ne case into High Court. Cause ye di kind of bremo say ya no contempt as is your case no omode kwa akopie mu ewo High Court amasan so release and as leaky new evidence against Chief Justice Torkonoo to a High Court judges. Yes, lawyer Martin Pegbu ede ensembi ababetuja afa ho. Momi yanko na yankonko ti ensema ekoso na answer na yebekono abusua o ensem kan bi afa share comment section like na share ma from so answer into me enkebi aha POG Media. So political trending stories are making waves so ya atum say ya de bebremo.
Petitioners and herself, and that the removal process is unconstitutional. It violates the dictates of the Constitution. It's illegal, and every manner of the process breaks every rule on how justice is delivered. That's her verdict. Take a look.
Unfortunately, every step of the removal process being undertaken against me is being done in a manner that breaks every rule on how justice is delivered in our country. And this is why I find the need to draw the nation's attention to the serious violations of the Constitution and law in the process, and the danger it holds for the development of the nation's democracy. The removal process being undertaken against me is being done in a manner that breaks every rule on how justice is delivered in our country. And this is why I find the need to draw the nation's attention to the serious violations of the Constitution and law in the process, and the danger it holds for the development of the nation's democracy.
Well, that's Chief Justice Gertrude Esaba Torkonoo, her ladyship. She has also indicated that, you're one of the first persons to have recommended or proposed to her that she should consider resigning, right?
Yes.
Right from the onset of this, she said she should consider resigning to save herself of, whatever will play out.
Yes.
She says it's not on the table. She has heard that advice that you offered, but it's not an option on the table. And this is why. Take a look.
Or retiring, while Article 146 proceedings are being conducted to remove a judge. It's not an option any judge or public official can even have. There is a decided case on the matter by the Supreme Court. The suit number is J6/02/2019. Again, no one has the authority to walk away from proceedings started by the state. Judgment can be entered against you because you fail to defend yourself. And a judge who resigns or retires would still lose all entitlements that they have worked for because they failed to defend the claims and resigned or retired while the proceedings were still going on.
Well, so to the likes, Lawyer Martin, of you who held that view and made that proposal, that's the answer to you. It's not on the table. It's not something that should even be considered because of the details you have just given. Counsel, that's a response to that proposal you made. That's just a quick one. Is it one you still stand by?
No. Oh, but you remember, coincidentally, that week, I was on the panel here of EDG. So EDG cited the Justice Amwa case. That one is even earlier, 2015. Right. That time JM was in his first term, right? And then, when each topic comes, you keep researching. You'll never finish researching. So when this press conference came and I went to look at the Justice Derry case, all right, Paul Derry case, all right, the Supreme Court mentioned that again. So, and then the Chief Justice has cited a third case. But this Justice Derry case is also 2015, 2016. So we had already, I mean, as I've said, the Supreme Court is the final arbiter. If they've said so, generally that's the law. But we can continue to advocate. Yes, I yield that there is a Supreme Court decision, but still there is also wisdom in the proposition that resignation should be afforded people in that class in certain circumstances, right? Yes, because to every rule you find an exception. So let's look at this. You know, Ghana has there's an evolving democracy. Now you've seen, because she doesn't have an option to resign, you see, she's fighting back. And with the way she's fighting back, you see all the things that she's throwing out. Yeah? I mean, come on. If we all look at our judiciary now and as our nation, I'm sure by now it will be clear to a lot of us that, oh, it looks like if we could get a resignation for her, it would have been better than this fight. Yes, because now she's dragging everybody down with her.
You say everybody, who?
The committee, right? The president, etc. I think too many people are being dragged down. You see, so, well, in a way, it's helping to break the virginity of certain topics. You know, certain topics we would never want to discuss because, you know, we've evolved. A few years ago, you didn't even want to talk about certain things in the courts. I remember even last year when we were discussing, when Chief Justice Torkonoo wrote a letter to Akuffo, and we said, no, it's unconstitutional, we're discussing it here. Hey, lots of lawyers were like, oh, why don't you leave this alone? So what I'm saying is that as a society, when it comes to talking about the judiciary, etc., it's a taboo topic generally. It's a taboo topic. But you see that with we are breaking it gradually. But with this press conference, too many boundaries have been broken. So now you see that the conversation is gone higher. And the way it's gone higher, you know, so many imputations of wrongdoing and etc. It kind of affects the system. It looks like this press conference has broken too many boundaries, brought in too many topics for discussion at a go than even the system can take. So sometimes when you look at it, then you see that, hey, Charlie, if we had arranged a resignation, overall would have been better. You see, because the truth be told, at least with the wrongdoings that have been alleged, I'm not going into them. So far, I'll just use what she has said, because I still go by the Supreme Court decision that, even in the Justice Derry case, that the fact that petitions have leaked or evidence have leaked, it's no justification for us to then descend and go in and discuss fully. No. In the Justice Derry case, they say if we did, it would be contempt of court. So even Chief Justice Torkonoo herself has opened herself up for a contempt case.
So would they address this press conference that she addressed? Would she have possibly swayed into the arena of contempt?
Oh, yes, possibly. Yes.
With this press conference?
Yes.
Giving out the details of the petition?
Yes. And everything is done. Yes, it's up to the committee to take it up to the High Court. So let's be very clear. The committee doesn't have powers of contempt for this to itself, but it has to then refer it to the High Court. But I'm sure she did a calculated guess, knowing that because of the office, she still occupies, she's suspended, she's not been removed yet. As a society, we will be slow to say she should be hauled to the High Court for contempt. Yes, I'm sure she knows that she has at least some goodwill not to be taken to the High Court for contempt. That's why she did that, right? But me, how can I guess that? So let me be careful, because it's possible that I will be hauled to the High Court for contempt and she would not be.
That is if you get into the merits of this
exactly matter. So
but
please,
she
let
had
me
reason.
steer clear of
she had reason why she did this, and even addressed the press. She had 4 stated reasons. You know, that she's the one going through it alone, but the effect reaches beyond her and so on. She had a position on the secrecy of this entire process and why she at some point, if you recall, during her application to the Supreme Court, one of the reliefs she was seeking was that there's some rights that she had that could be waived, and this whole process telecast so that we would see what the process of the hearing is like. The Supreme Court did not grant that. So she sought to give out the details through this press conference, which you say has slipped into the arena of contempt. But she had reason why this entire secrecy of the process, she says, will not prevent her from putting out some matters in the public so that the public will know. Those were her words. But take a look at this.
I applied for the proceedings of the committee set up by His Excellency the President to be held in public, so that in the interest of transparency and for the truth in the matters being raised to be made known to the people of Ghana. I did so because I knew that the secrecy of the proceedings for removing justices was not created in the Constitution as a cover-up for any agenda. The Constitution expects that only reasons for removing the Chief Justice and public officials as set out in Article 146 will be the reason for doing so. And especially, such reasons must affect public sensitive national interest or public order or safety.
It shouldn't be used as a cover-up for any agenda whatsoever, this secrecy of the process, as enshrined in the Constitution. So in her view, people must know.
Okay. So, Mr. Kansi, yes, she said she had a reason for doing so. But when you read everything, okay, sum up everything she's done, those are grounds for her to go to the High Court. And indeed, she's done it. So she's in the High Court too. She's filed an application for judicial review.
Yes.
So ordinarily, if I had filed such a case and I came here and started going to the details, quickly, Edu will point out that, hey, Martin, you have the case in the High Court. Stop. You can't do this. I can only mention that maybe I've sued. But to go into details like she did, lawyers would have called in contempt, right? So, Mr. Okansi, everything she said, she's already before the High Court. These are matters before the court. That's why I said that, yes, the lesson we are learning from it is that there is equality in the law, but to every rule too, there are exceptions. Yes, that's what we should learn. I mean, yeah, we are all equal before the law, Article 17 of the Constitution. But when you even go to Article 17, you see positive discrimination, all right? That, I mean, you know, with certain areas of our society, people are vulnerable, etc. We should help them, right? So Chief Justice Torkonoo also knows that, well, yeah, she served Ghana to the highest extent, and so people will not lightly say that, take her to the High Court for contempt. That's how come she has the leverage to do what she did. But of course, lawyers who have been very clear in reprimanding Chief Justice Torkonoo that, no, please, yes, we reckon that you've served, but this one is a bit too much. So that one too, we'll put it on record that it's a bit too much. But overall, it's because of the service she's rendered. That's how come she can get a bit of more leverage than the ordinary lawyer or any other person for that matter. So the reasons are not sufficient for what she's done, because the law is very clear. You read from Frankie J. Chum, all the Supreme Court decisions, like we don't have to be mentioning the name, let's just go on with the main arguments. All the Supreme Court decisions are clear that for these proceedings, we shouldn't come out and discuss their merits. And that even after petitions and evidence have leaked, it is still no excuse to continue. It is still no excuse to continue the debate. So stop. That's why I mentioned that Chief Justice Torkonoo may be free. I may get into trouble if I waded in too much.
But has she done herself any good in addressing the press this week and putting out this detail? Has it helped the case for her in the court of public opinion in any way?
You see, the jury is still out, right? The jury is still out. So for that, I'll be slow. The jury is still out, because remember that she has supporters, right? And also me, even a certain part of me too, earlier on when this matter came on, I'd advocated that in the next constitution, and H. Kwesi Prempeh, chairman of the Constitution Review Committee, has also put it out that we won't have that blanket in-camera proceedings anymore. No, that's anachronistic. We've gone past that. even the Western world, look at US and co, where they came to learn civilization from us. In the US, it's done in Congress, it's open. Then they vote on the matter, right? Yes, it's done in Congress. That's open. So the hearing is done, then they vote openly. Why are we hiding it? We've grown up as a society. I think, yes, we are still evolving. Colonialism truncated our growth, etc. But as for holding this Article 146 proceedings in public, I think we've reached there. And that's how come, maybe, as I mentioned, we'll make provisions for resignations to, etc. So we blend the two. Because currently, you can see that Ghanaians are yearning to know what's going in there. But, sorry, the door is shut, firmly shut on us. That's not good for our democracy. When we make it open, it's also a form of accountability to all Article 146 office holders. Let me say Article 146 office holders, because this Article 146 doesn't apply to only the Chief Justice, nor the Superior Court Justices. When we say Superior Courts, that's High Court, Court of Appeal, and the Supreme Court. No, it doesn't apply to them alone, but also Shraj commissioners, NCCE, and then Electoral Commission. They are also then NMC, National Media Commission. All these people is the same thing. Article 146. If you want to remove them, you go through 146. Right. So because of that, I mean, you look at it, it will help in accountability. Let's say if we knew that, hey, once you are in a certain office, when you did anything wrong and they are going to do the hearing, it will be broadcast live. Generally, every day, in everything you did, you would be careful, knowing that, hey, this thing, if it comes out, they will discuss it publicly. So that in itself will put fear in the office holders to walk the straight and narrow. And you see, earlier on, Eduji mentioned the live beyond reproach, Caesar's wife's test. Yes, in the Justice Paul Derry versus Anas Tiger PI, etc. They mentioned it. The Supreme Court said, yes, Caesar's wife's test applies. Okay. So if you want to avoid trouble, it's good. So that all of us are held in check, right? So so the point is that the press conference is done, is advocacy for us to amend the Constitution. Amend it, that's in future, but this current one, we are stuck. So remember when the topic first came, like one of the times we discussed it a few weeks ago, I had said, oh, we should go and do, Musa Dankwa should do a poll, etc. But the responses from citizenry on this program and panelists and everything was very clear that, listen, once this Constitution says in camera, please go by it. I agree. So these arguments about make it open, that's in the future Constitution. Please, to be clear, these arguments that make it open, etc., we are talking about the future Constitution that H. Kwesi Prempeh and the rest are crafting. But as for the current proceedings, the law is clear. The law is the law, no matter what I see. It says that it should be in camera. And so we are following the rules on in camera proceedings. Right. I see.
Let me bring in Digital Maklo on this matter, because the Chief Justice was quite clear. And we'll put that on the screen. The 4 reasons why the suspended Chief Justice did this press conference, as she put out herself. These were the 4 reasons. They said the removal process is historic with higher stakes, but then again, the position is that this process has been reduced to ordinary litigation between the petitioners and herself. The process itself is flawed, it violates the Constitution, and the manner in which it's being done breaks every rule on how justice is to be delivered. 2, the far-reaching implications of the process goes beyond her, and its effect reaches beyond her as an individual. And the alleged constitutional violations and illegalities of the proceedings, as she put out there, about her lawyer not being admitted before the committee because she didn't accompany him, and the family, and so on. And then the final one about the calls for resignation says it's not on the table, and the alleged threats on her life. She put that there as well, that her resignation will be an admission that this flawed process is acceptable.
Political highway, so Chief Justice Torkonoo NSCC 5-members committee omorena kwa kopiemu ewo high court enye asam ketwa kra beda masese moje pene kokoti sa ensemwe edemai aha POG Media so medamase.